Hey folks, I'm cutting a short series of videos here to show what I've exposed here in Isabella County, Michigan, and it's judicial terrorism, and I'm being forced right now to participate in these local courts that I've seen to be corrupt. I know to be corrupt. I know 4 judges in particular to be corrupt. Most recently, Eric Janes recognized my standing to be in court and sit at the table, you know, on that side of the bar, and then told me I technically didn't have standing to defend myself in the eviction here. And I'm going to kind of work backwards from that. Prior to that, I've been working with the Daniel Austin case, and I just posted a video about William T. Irvin. He's another terroristic judge here in Isabella County. He's either rubber stamping these summons and petitions summons to court on the same day respondent CPS parents are to appear, the same exact day. And that video shows that the process server is required to file a proof of service for those proceedings, that type of proceeding, and in there is directions from the court to the process server to serve them in accordance with Michigan Court Rule 3.920B5. Which says they'll be served personally and 7 days prior to the hearing. So that's William T. Irvin's part in all this. Mark Duthie, I caught him lying in Daniel Austin's case. He came in on February 10th, 2015 in a transcript. I have it right here. I'll read it. Real quick, Tuesday, February 10, 2015, 10:48 a.m. court. And this is Mark Duthie talking, and I recorded him, okay? And that's going to bring up Paul Chamberlain's terroristic involvement here. Mark Duthie says, I'm going to call the case involving the following minors, the Austin minors, Madison, Marcus, and Michael. Case number 14-099-NA. Then he goes on to say, this is Mark Duthie, folks. This is the first time I've been involved with this case. I think it's been heard by the referee a couple times. And then he goes on, blah, 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 blah. My point here is that Mark Duthie signed the original order in this case several months prior, and his name's all over this case file. So, I don't know if he knew I was recording or we were getting rid of, Danny was getting rid of her lawyer at this time, but Mark Duthie wanted to state on this record, and it's the first thing he said. He said, here, okay. Read that. Anyways, he wanted to put on this record that this was his first involvement in the case because he was expecting an appeal. And the reason Daniel Austin didn't appeal is because the case against her never existed in the first place, which you'll see in another of the videos. But anyways, I recorded Mark Duthie saying this, okay? And Paul Chamberlain, in response to me recording Mark Duthie lying in court to save his ass, basically, in the eyes of the appellate court, creates an administrative order 2015-2. And this order prohibits and bans the First Amendment from the Isabella County Courthouse under color of law. That's just bullshit, okay? Paul Chamberlain's a terrorist. Now, administrative orders are supposed to be submitted to the Supreme Court. They need to be authorized. They need to be approved. Any monkey can create a rule or an order or a policy, okay? But there's a procedure here, and it's outlined in the Michigan Court Rules 3.112. And we have to stop allowing this shit to happen, okay? You know, people ask me why I don't want to just, you know, file an appeal or go spend more money here or, you know, go get a lawyer here or do that. I understand this stuff, folks. Michigan Court Rule 8.112, Local Court Rules, Administrative Orders. Now, a trial court may issue an administrative order governing only internal court management. Now, I didn't write this stuff, okay? These guys aren't following their own rules. Okay? I went out and spent $135 to get access to the Michigan court rules annotated, which are a hell of a lot more descriptive than what we'll be able to find on the internet without that. And here they are right here. I printed them, and I'm going to send this to the Isabella County Court Administrator tomorrow. 8.112 Local Court Rules Administrative Orders. Okay, now 8.112 B5, I'm sorry, B3. Before its effective date, an administrative order must be sent to the state court administrator. If the state court administrator directs, a trial court shall stay the effective date of an administrative order or shall revoke it. Sorry. A trial court may submit such an order to the Supreme Court as a local court rule. Now, because they have to, if Isabella County wanted to make local court rules, they would have to submit it to the Supreme Court, okay? But we're not talking about a local Isabella County court rule. We're talking about an administrative rule or policy. And before its effective date, an administrative order, and that's the same as a policy here in Isabella County, must be sent to the state court administrator. Now, I got a letter back from the Isabella County Trial Court Administrator. Her name is Carrie Curtis, and I'm putting this out a little bit prematurely. I wrote a letter to her, and I said, hey, look, I know you might not realize what's going on here, but you're actually participating in the intentional deprivation of constitutional rights under color of law, and that is a federal crime under Title 18, Sections 241 and 242. So in her letter, she says, please find and enclose a copy of internal policy. See, now she's calling it an internal policy, but the way it's numbered tells me and tells the world and tells the court that it's an administrative order. Okay, but here she's calling it an internal policy. Okay, now, and if it's internal, why does it have any impact or effect on me? Okay, keep these things in mind. Neither 2008-2 nor 2015-2 require the approval of the State Court Administrative Office. Well, of course they do. It says it right in the court rules. So anyways, I've given her a chance. Let me just finish reading here. A list of local administrative orders that require approval by the State Court Administrator's Office is available by either contacting the SCAO or reviewing the list on their website. One more time, I'm going to slow this down for you because people read this stuff too fast, and that's a shine job, okay? I don't think Carrie Curtis wrote this, and I'm going to give her an opportunity to more clearly state her position here, but a list of administrative orders that require approval. Okay, in the court rules, it doesn't say some require, some don't require. Administrative orders are pretty general. They're created by the chief judge, and before they have any force or effect on the court staff, whom they're supposed to be administering with these administrative orders, it needs to be approved by the Michigan Supreme Court through the State Court Administrative Office, I would presume. So anyways, she's telling me here, and again, I don't think she wrote this, a list of local administrative orders that require approval. Well, hold up. All of them require approval if you intend to enforce them, and that's the other part of my argument here. Paul Chamberlain can create administrative orders until his eyes fall out, okay? For any of them to have any force or effect, they need to be approved by the Michigan Supreme Court. Bottom line. So yeah, Paul Chamberlain, you can create as many administrative orders as you want to, but you have to go to the state Michigan Supreme Court and get approval, okay? You can't just approve the shit on your own, jackass. And that's exactly what you're doing. And that's a terrorist activity, okay? 2015-2 essentially bars the First Amendment for Michigan courts. Did you get that, people? Come on. We're barring freedom of the press from the courts here in Isabella County by a chief judicial terrorist that's creating administrative rules without the authority or without the blessing of the Michigan Supreme Court, and he's imposing it on the people rather than the court staff, rather for the internal management of the court, and he's enforcing it, okay, without the Supreme Court authority. This is the willful deprivation of rights under color of law. It's a federal crime. And people ask me why I don't want to play in the court, okay? You know, I've learned how to be a lawyer. I've taken the Michigan bar 8 times, okay? I passed it 7. I know what I'm doing here, okay? This stuff is not hard to read. I'm talking about 3 or 4 pages. You know, it's about knowing where to find it, knowing how to apply it. Anyways, I'm here in Michigan, and I'm trying to help respondent parents in Michigan that are dealing with these terroristic courts that can't even follow their own rules. Okay? We don't have justice in Michigan right now. We don't have courts in Michigan right now. So when you ask me why I don't want to play, well, here's why, folks. And none of us should be playing. None of us should be giving all of our hard-earned money to lawyers to go muck it up for us. Anyways, till the next one. Bye.